Good morning. My name is Sarisha Ganta. I'm Counsel and Education Director with the Pro Bono Partnership of Atlanta. Thank you for joining us for this month's installment of the Pro Bono Partnership of Atlanta's monthly webcast series. I'm excited today to have Ron Coleman, a partner with Parker Hudson, and Robin Miller, attorney with Pro Bono Partnership of Atlanta, here to talk to us about legal considerations for when a nonprofit is using content or IP created by its founder. Before Ron and Robin talk to us about today's topic, I wanted to take this opportunity to share with you a little bit of information about the mission of Pro Bono Partnership of Atlanta. We seek to provide free legal assistance to community-based nonprofits that serve low-income or disadvantaged individuals. We do this by matching eligible nonprofit organizations with volunteer lawyers from the leading corporations and law firms in Atlanta, such as Parker Hudson, who can assist nonprofits where their business law matters. If you're interested in becoming a client or finding out more information about us, please check out our website. Our clients are all 501c3 nonprofits that are located in or serve the greater Atlanta area. These organizations serve low-income or disadvantaged individuals and are otherwise unable to afford legal services. Also, on our website, you'll find a ton of great resources, including past webcasts, articles, podcast episodes, and information about future events. In normal times, and hopefully in a few more months, we also offer live in-person workshops that are open to the general public. And a quick disclaimer, some legal information about today's topic. Please keep in mind it's general information. If you have specific questions about your nonprofit situation, please reach out to an attorney for specific guidance. Today's information is copyrighted. And if you have questions as Ron and Robin are speaking today, feel free to type them up in the chat box at the bottom. And now I'll turn it over to Ron.
Well, good morning, everybody, and thank you for attending. I want to first thank the Pro Bono Partnership of Atlanta for the opportunity to participate in this. A little bit about me. I'm a litigator and trial lawyer with Parker Hudson. I've practiced for more than 30 years, and a large component of my practice involves litigation and counseling in the area of intellectual property, which I think is one of the most fun and interesting and challenging areas of my practice. And I'm pleased to have the opportunity to talk to you all about IP in the context of the nonprofit world, and in particular, issues relating to intellectual property generated and brought along by founders. I want to just briefly kind of set the stage. When people think about intellectual property, often the first thing that comes to mind are patents or complex technology or things like that. And in the nonprofit world, people may think, well, we don't deal with that. That's not us, so we don't need to worry about intellectual property issues. But in fact, intellectual property issues are much broader than many people think, and they really touch all aspects of business or a nonprofit entity or an organization. And intellectual property really is all around us as we kind of go through our day from morning to night. Driving into the office, which I did this morning, and hopefully we'll all do again sometime soon. Going down the street, you see trademarks and you see some copyrighted material. Turning on your television, opening your newspaper. I'm old enough to still open a newspaper every now and then. You see intellectual property content that's created. Going online, social media, that's full of intellectual property and issues relating to that. So it really is all around us, and in many ways, it's something that a nonprofit does need to be aware of and focused on. I want to reiterate what Sarisha said. We're going to cover a lot of material today between Robin and me. I encourage those who are attending to ask questions, both for yourself and, frankly, for others. I understand this is being recorded, and hopefully will be a resource for people down the road, and so questions will help those folks too. So let's get started and talk about some of the goals that we want to achieve in this hour. We're going to start with hopefully giving folks at least a general understanding of the types of intellectual property that most nonprofits deal with, or that you may deal with in the context of your nonprofit operations. We're not going to try to turn people into intellectual property lawyers, but we are going to try to help you spot issues relating to intellectual property generally, and particularly to founder intellectual property issues. Because if you spot issues, you can try to get out in front of issues and deal with them before they become a problem. We're going to talk about best practices. That's hopefully a takeaway that will be valuable for everyone. And we're going to hopefully help you identify when you can benefit from going to seek the professional advice that's available to you through pro bono partnership and maybe other sources. And then something that I'm not going to be able to be any help on, but very fortunate that Robin is here, is to stay on the right side of tax law, because there's some very significant issues that we're going to talk about that are really important in the nonprofit context. So just quickly, the agenda about the substance we're going to cover. We're going to spend a few minutes at the beginning with me covering basic intellectual property concepts. What are the things that may come up that hopefully can help you spot issues that you may be dealing with. Then Robin's going to take over and talk about some of the tax considerations and those issues. I'm going to jump back in and talk about some common types of intellectual property that may be created or used by nonprofits, some of the specific founder IP issues that can arise. And then talk about some best practices. And if we have time, we'll talk about some other intellectual property considerations as well beyond the founder IP issues. But again, I want to emphasize to please type your questions in the chat box, and Sarisha will help us along the way. So there are 5 types of intellectual property that generally arise in most businesses. They are copyrights, trademarks and service marks, patents, trade secrets, and right of publicity and name and likeness. And as I said, people think about patents. That's kind of the first thing that comes to mind when a lot of people think about intellectual property. Copyrights and trademarks are really important aspects of intellectual property that nonprofits need to deal with, and we'll see that in a minute. Trade secrets and right of publicity are things that a lot of people don't think about, even people who realize IP extends beyond patents and it covers copyrights and trademarks. That's still something, those 2 areas, trade secrets and right of publicity, are things that I hope as a result of today you'll have a little more awareness of. So let's talk first about copyrights. Copyright is one of the most common types of intellectual property that businesses and nonprofits in particular have to deal with. Copyright protects original expressions of ideas, original expressions of creative thought. It does not protect the idea itself or the fact itself. One of the areas that I've done a lot of litigation in is people who write screenplays and write a 3-page treatment for a screenplay about aliens coming in from outer space, and then they send it off to movie studios, and 2 years later the movie studio creates a movie and some aspect of it involves an alien from outer space, and they say, well, that's you infringe my copyright. The idea of something is not protectable, but the specific type of expression is protectable. And that's what copyright protects. It must be original and have some creative spark, but that hurdle is fairly low. The phone book, compiling names and phone numbers in a phone book, again, that kind of tells you how old I am, that I used to have printed phone books around, was held not to be protectable. That was not creative enough. But pretty much anything above the phone book has the potential to be eligible for copyright protection. Copyright exists to protect things that are put in what's called a tangible medium of expression, or a tangible form of expression. Walking around with the idea in your head, or walking around with the world's next great poem in your head is not sufficient to create a copyright. It must be put in some sort of tangible media. Now, that can take any form. It can be scribbled or typed on a piece of paper. It can be recorded. It can be typed into a computer, and it can be an electronic computer file. So it can be in any type of tangible form of expression, but it needs to be tangibly fixed. Examples are really abundant of copyright protected works. Written works, books, manuals, even short writings, postings on social media can be copyrighted. Pages of a website can be copyrighted. Visual works, photos, artwork, those are some of the kind of quintessential things that can be copyrighted. Musical works and sound recordings, computer programs and software in some instances can be copyrighted. You can get a federal certificate evidencing your copyright, but you don't have to have it. You have to have it to sue. You don't have to have it to own it. We'll talk about that a little bit later. But copyrights is one of the most common forms of intellectual property that businesses and nonprofits can deal with. And a lot of the founder-generated material is likely to be written material put in some sort of tangible medium of expression and subject to copyright. Trademarks are next. Trademarks are maybe, to me, the most fun area of intellectual property because I like, in my younger days, I like to eat McDonald's hamburgers. I like to, wear T-shirts with a Nike swoosh. I like to get a cup of Starbucks coffee. And so you just see trademarks all over the place. A trademark is a word or a symbol. There's some other things that can be trademarks, but most of them are words or symbols that indicate the source or who is behind a particular good or service. Where is that good or service coming from? What should you expect from the good or service? You see the McDonald's Golden Arches and kind of love it or hate it, you know what that Big Mac is going to taste like in any McDonald's you roll into. You know what to expect when you go into a Starbucks and order their coffee. So it tells you where the product is coming from and what to expect. What's the brand? It's not an exact analog, but trademark signifies a brand and the meaning behind that brand. Trademarks are entitled to different degrees of protection depending upon how distinctive they are. And that's probably a little more detail than we need to get into today. But, one of my favorite examples being here in Atlanta is the Buckhead Diner. If you just use the Buckhead Diner as a trademark, that's a location and a generic thing. And when you first start out, that probably isn't very distinctive. But the Buckhead Diner's been around. It's actually closed during COVID. They're supposedly going to open it back up. But the Buckhead Diner's been around for 30 plus years, and it's developed a distinctiveness such that it can be a trademark. Something like, McDonald's that's been around for 70 years, or a Nike swoosh, or things like that may be more distinctive. You can get a federal registration for your trademark, but you don't have to. You have trademark rights whether you have a registration or not. The registration gives you certain additional rights. Again, that's probably more detail than we need to go into. Nonprofits often deal with trademarks. Their name itself may be a trademark or may evoke trademark rights. They may deal with trademarks in the context of referencing or using the trademark of others, sponsors, or other people who interact with the nonprofit. The trademark law is an important area that you need to be aware of. Patents, fortunately for you and for me, we're not going to spend a lot of time on patents other than to say that they're out there. They protect inventions, generally machines or methods of operation. A patent, a copyright is good for a long, long time. The life of the author plus 70 years, can even go up to more than 100 years in certain situations. Trademarks exist as long as those trademarks perform their source identifying function. There's really no expiration date on that. Patents have an expiration date, 20 years from the time of filing. You have to disclose it publicly, so the patent goes into the public domain after the 20-year period. It's a hard thing. It's a hard process to get a patent. You got to go through a detailed examination process. There may be some nonprofits out there who either own patents or for which patents are important. None immediately come to my mind, and so that's probably not an issue that you're going to have to deal with to any great extent. Trade secrets. We're now getting into the couple of areas that most people don't think about as intellectual property that applies to nonprofits. And hopefully part of what you get out of this hour is information that tells you this could be an important aspect of your intellectual property. Trade secrets are essentially confidential or proprietary information that helps you run your business and that is competitively valuable in some way. It can be developed in the course of your business. It can be acquired, but it has some competitive value. It's information that has some competitive value versus your other competitors in your area of operation. There's a federal law, actually relatively recent, only about 5 years old. There have been state laws that protect trade secrets. Georgia has one that's been around for a long time. So they're a little bit different from patents, trademarks, and copyrights that are generally governed by a pretty well-established federal statutory scheme. Trade secret has a very broad definition. The basic definition is that it has to be information of any kind. It can be a formula, it can be a plan, it can be a list, information of any kind that has some type of economic value by virtue of it being not generally known, by virtue of you knowing it and it not being generally known by others in your industry. There has to be some limitation on how other people can create it. It has to be generally difficult to create through legitimate means. And this is one of the most important aspects. You have to take reasonable efforts to maintain the secrecy of it. So, posting your trade secret formula on the wall of your restaurant is not going to qualify as a trade secret. But keeping it, in password protected computer files or back in the old days, locked file cabinets, those types of things are what is meant by reasonable efforts to protect secrecy. A trade secret can exist for as long as it remains valuable and a secret. And the best example, being here in Atlanta, is the Coca-Cola formula. That's not a patent, that's a trade secret. And Coca-Cola has protected that formula for more than 100 years, and it remains, among the most valuable parts of its business. Other types of trade secrets, I mentioned recipes. Everybody loves to talk about Colonel Sanders' secret 11 herbs and spices. That's a trade secret. Client lists, customer lists in most businesses, those are important trade secrets. Business plans or strategies. A lot of the litigation I do is with people who leave one company and he or she might have been the vice president for head of marketing, and they go to a competitor, and the marketing plan was an important trade secret that needs to be protected. There is no registration process. You don't go to the state or federal government and register your trade secret. You just have it, and we'll talk about some best practices toward the end of how to make sure you know what you have. But you have it, and you use it when you think somebody else has taken it, misappropriated it, or otherwise is infringing on it. I think this is an area that most nonprofits don't think about. But think about your donor information, your volunteer information. That can be highly valuable. It can be, you don't think of a nonprofit as having competitors in some ways, but it can be competitively valuable. There are a limited number of people out there who give money to certain causes, or they have a limited amount of money to give. And so the fact that they have been long-term supporters of your cause, and you've got records that reflect that, that can be protectable information. So that's why I said most nonprofits have trade secrets, but a lot of them don't know it. I will mention an interesting matter that I saw filed about a month ago in state court over in DeKalb County. A nonprofit sued someone who left and started a competing nonprofit for taking their donor information, and the case was a trade secret misappropriation case. So I hope you don't have to deal with that type of situation, but you should know that it exists, and you should know that it can be valuable. The last type of intellectual property, and again, most people don't think about this, but in the age of electronic communications and the internet and social media, this is becoming more important, I think, than it ever has been, and that's what's called the right of publicity. It's not technically an intellectual property concept in the traditional sense, but it is definitely, it's treated as intellectual property, and it's something that I think nonprofits often aren't aware of and stumble into trouble in this area, and they should be aware of. And what it is essentially the right of a person to profit or to protect from others using his or her name, likeness, or other ways to evoke that person's identity. And it protects against having someone else appropriate or use the value of your name or likeness or image without your consent or without authorization. And the examples I put in here, and I don't mean to be, flippant or frivolous with using the Martin Luther King bobblehead example, but the first Georgia case from either the late 70s or early 80s that recognized right of publicity under Georgia law had to do with someone who put out a Martin Luther King bobblehead. And the King estate sued and said, you don't have the right to do that without our permission because we own the rights. The estate of Dr. King owned the rights to his right of publicity. And a Georgia Supreme Court agreed with that and granted the estate the right to shut that down. And now, I'm being very serious, you go online and there is a maker of bobbleheads that is officially licensed by the King estate to make and sell Dr. King bobbleheads. And that's an example of the ability of a famous person to, even after his death, to control and profit from legitimately that name and likeness and image. Elvis is on there too because Elvis was one of the kind of trailblazers. The estate of Elvis Presley was one of the trailblazers of litigating and protecting rights of publicity. More recent entertainers, Michael Jackson and his estate, have been very aggressive about protecting rights of publicity as well. These are based on state laws, so it's kind of a patchwork of laws or judicial decisions that protect it. But this is an issue, and we'll talk about some examples later on that nonprofits encounter. And it can be an issue with the founder if the founder is no longer associated with the nonprofit. So these are common examples of types of intellectual property. We kind of covered those as we went through. I'm going to move on so I can turn it over to Robin and talk about some of the tax issues.
I have a quick question
that
I wanted to ask generally about intellectual property. If there's no agreement that indicates that product created is proprietary, is it still intellectual property?
If there is no agreement that it's proprietary, you don't have to have, if you create a product or information that is proprietary to your organization, you don't necessarily have to have an agreement. If you are trying to acquire intellectual property that someone else created, and we'll talk about this in a few minutes as it relates to copyrighted work, but generally the best practice is that if you are acquiring information or products that someone else created, then you should have some agreement transferring or licensing, that is authorizing you to use that information or
Thank you.
intellectual property. I hope that answers the question.
All right. So as we talk about founders, I wanted to bring out a couple hypotheticals and kind of put it all into context about what some of these issues are, particularly from a tax perspective. So now we've learned about the overview of intellectual property. I'm going to kind of give you some of the tax perspective, and then Ron's really going to jump in and talk in more detail about the realities of how these different types of intellectual property rights can play into a founder's use of them or creation of them and a nonprofit organization. So this issue has come up a number of times with our clients. Writing a book. A Nonprofit A's founder writes a book about her life's journey and experiences, including how she overcame homelessness and a lack of education. It includes stories of her helping others to overcome these issues as part of her work through Nonprofit A. The founder wants full copyright ownership of the book and all proceeds, but does want to donate some of the proceeds to Nonprofit A. So is this something that Nonprofit A's founder can do? She is talking about her personal experiences that are hers, but she's also talking about how she did her work through Nonprofit A and how Nonprofit A has helped others to overcome similar issues. And she is the founder of Nonprofit A, but Nonprofit A did and does these things. So who has what rights to the proceeds of these books? And so I just want to set that as a stage as to how you should be thinking about these things as we start to talk through this process. Right. The main issue that I want to identify from a tax perspective is private interment. So all 501c3s cannot have any private interment. And what is private interment? Interment isn't even a word in the dictionary. It's only found in the Internal Revenue Code. So what does that mean? Basically, it is an insider benefit. So beyond what they should get, an excess benefit to an insider. So it can be an arrangement with founders, officers, directors, substantial donors, and family members thereof. That's what constitutes an insider, right? It's anyone with control or influence over the organization in the past 5 years and their family members and affiliated companies. So it's pretty wide ranging and it lasts for a long period of time. So if you're the founder, or let's say you're an officer of a nonprofit and you leave, well, you remain an insider for 5 years after that, as well as your immediate family members and any affiliated company that you have, which means that you own that company 35% or more. So it's a pretty broad net. And control or influence is the key element here. So you could certainly have substantial donors that have control or influence over the organization, and they have to be considered when you're thinking about private interment. But the key here is that if you've got this insider and they're getting some kind of benefit that's excessive, that's beyond what they should in return for what they're receiving, then you've got private interment. You know, the extreme example of this would be where there's an organization that was the largest nonprofit in the United States, the Bishop Estate, and the directors were getting $1 million a year in salary. And they met only like a handful of times. And they were giving out contracts to their friends and relatives for work that wasn't being done, but they were being paid for it. So that's the extreme example of private interment, where you give a contract to your uncle, you're on the board, you give a contract to your uncle, and it's $100,000, and he does no work and he still gets paid. That's private interment.
But in our situation, what we're talking about, private interment, can be as simple as if all of the proceeds of the book that include the stories of nonprofit A, which is nonprofit A owns those stories, and Ron's going to go into that in more detail, but because I'm not the IP expert, but from an IP perspective, if all of the proceeds from that goes to the founder and none of it goes to the organization, or the organization doesn't have a say in how much they get of that, that could constitute private interment, and you have to be careful of that. So what's the risk? Well, the ultimate risk is loss of exemption. And there's parts of your Form 990, the full Form 990, that you have to answer some of these questions, particularly about excess benefit transactions with insiders. But because the only option was loss of exemption, and going back to my example of the organization that had the $1 million directors and so on, the IRS did not want to remove that organization's exemption because the work that it was doing was really critical in helping children who really needed that assistance. And so eventually they convinced Congress to pass what's called intermediate sanctions, which is basically a system of fining and penalties for these kinds of scenarios. So they said, let's go after the bad actors. So what they said was that if you're paying more to an insider than you should receive, the insider must immediately pay back the excess that they received. So if the contract was worth $100,000 and the insider got paid $150,000, the insider must pay the $50,000 back within the same tax year and then pay a 25% tax on that. So 25% of the $50,000. So they pay another, so they pay $12,500 in addition. However, if they don't pay it within that same tax year, they owe 200%, which means they owe $200,000 more to the IRS. But in addition, those who made the decision to approve that $150,000 transaction that should have only been $100,000 also are personally liable for a penalty, and that is 10% of the excess amount. So in this case, 10% of $50,000 or $10,000. So it can add up pretty quickly, and then there's interest and penalties on that, and there's no D&O insurance to cover this. So intermediate sanctions is what they usually use in addressing these kinds of issues. And I raise all this really to say that you need to take time to really think through transactions involving insiders, particularly in ownership of IP and personal benefit associated with that IP. And so it's important to know who created it, who owns it, how is it created, and Ron's going to go into all that. And to determine, is this the nonprofits or is this the founders, and how to properly address those circumstances. And I'll leave you with one other hypothetical that comes up a lot as well, another common area to be thinking about. Executive Director Joan works for Healthy Living Nonprofit. Joan is an RN who spent 10 years specializing in nutrition and advising patients how to live healthier lives. As Executive Director for the past 5 years, she's developed many innovative programs. She's taught parents and children how to live healthier lives, and she's even been recognized by the President of the United States for this work. So she's approached by a speaker bureau, which is often how it works. Speaker bureaus really rarely will work with a nonprofit directly, which makes this a little more complicated. But she's approached by a speakers bureau to contract with them for speaking engagements. Now, her salary at Healthy Living isn't much because she wants the organization to thrive. So she's always given something up to help the organization to do its best work. So this contract, excuse me, would really help her out. So the question is, can she sign this contract and take money from these speaking engagements? And I think there's a lot of questions to consider there. What's she talking about? If she's only talking about her previous life as a nurse and the Healthy Living program that she kind of developed before she became executive director and created this nonprofit, then it could be all her money. But if she's talking about healthy living and the work that they do as part of this and these programs that are part of healthy living, then that money may be attributable to the organization, and how you deal with that, and how the organization then works with its board to analyze what can be done and how it should be addressed. So I just want to put all that in your mind and have you thinking about that as Ron then continues to go through all these various common problems and issues and addresses it really more from an intellectual property perspective, because that's really the basis of these issues. Is once you identify who kind of has the ownership of that, then you can figure out how the organization and the creator should manage that ownership.
Thanks, Robin, and we'll refer back to those hypotheticals in the next few minutes as we walk through some common founder IP-related problems. But one of the observations I wanted to make after listening to the tax issues that Robin has laid out is intellectual property law does not always resolve who's entitled to get paid what. Who's entitled to the money? It can be a separate issue from who owns the intellectual property that was created or is being referenced. Now, there's certainly a lot of overlap, as I think you'll see over the next few minutes, but we do need to keep in mind that tax or payment issues are not always IP issues, but they do share some common kind of practical best practices, which is the board and the people running the organization getting out in front of these issues and dealing with them as they, hopefully before they arise, but at least as they arise, so you can get to a common understanding and agreement that is consistent with the mission of the nonprofit, consistent with the tax laws that you need to obviously scrupulously abide by, and that also protect your intellectual property as you go forward. So just keep that in mind, that there's not always an overlap between some of the payment issues and the IP issues. But let's talk about some specific IP issues that relate to founder IP, and we can reference back to those hypotheticals, the book hypothetical, the founder writes a book, the Speakers Bureau hypothetical, where the founder is called upon and paid to give speeches. I think there's a significant distinction from an intellectual property standpoint about whether you are talking about content, and sometimes I'll say content as a proxy for intellectual property, because most of the IP that we're talking about here is likely to be copyright related IP, and that's content. That's an expression fixed in a tangible medium. Was the intellectual property created by the founder before organizing the nonprofit, or was it created or possibly modified after founding the nonprofit, but maybe before there were definitive arrangements or policies or agreements in place? I think that's a really important threshold issue. If you go back to the book example, as we'll see in a minute when we do a little bit deeper dive into copyright ownership issues, if a founder writes a book about all the great work he or she did that may have led to the nonprofit, but that content was created before the nonprofit was founded, then it's going to be pretty clear under copyright law that the founder owns that intellectual property. If it was written, on the other hand, kind of as an employee, once the founder formed the nonprofit and was employed by the nonprofit and was done in the course of his or her job at the nonprofit, then that's a little bit different. That's a different issue. So let's do a little bit deeper dive into kind of key questions regarding ownership of a copyright. And so the basic principle of who owns a copyright under the federal copyright law is the copyright is generally owned by the creator of the work. That's the starting point. So if I sit down and I write a speech or a book or an article, the starting point is that unless one of these different situations apply, I own the copyright. However, if the work is created by an employee in the course of his or her employment, then the employing entity typically owns the copyright. There's a concept in copyright law called work made for hire, which is actually a fairly limited and is not directly related to the employer-employee context. But if you're an employee and you create the work in the course of your job using the employer's tools, so to speak, or on the employer's time for the benefit of the employer, then the employer owns it. If you're an independent contractor or a third party, the situation is different, and this trips people up a lot. If I hire somebody to do something if I hire somebody to design my logo of Ron Coleman, attorney at law, I don't own that logo unless I get an agreement where they assign the copyright rights to me. Now, I have the right to use it because I paid for it, but a lot of people don't realize if they commission an outside party to create a work that's eligible for copyright protection, you don't own the work unless you get an assignment from the person who created it. Now, there are some limited exceptions, which is the work made for hire concept in the copyright law that ownership transfers automatically. But you just need to be very careful if you engage a third party to create something for you. You need to make sure you have a written agreement in place that transfers the copyright. So did the founder create the work as a nonprofit employee or separately? If she created it as a nonprofit employee, if she wrote the speech, if she wrote the book, if she created the video, then that's most likely going to be the copyright owned by the nonprofit. However, it is very important to think about agreements, and most businesses that are really tuned into IP issues and want to protect their intellectual property rights with respect to things done by their employees have employment agreements that in the agreement says you agree that anything you do in the course of your employment is owned by the employer, and you hereby assign and agree to execute in the future all documents that need to be executed to confirm and transfer ownership of any inventions or copyrights or other intellectual property you create. Now, that's probably the exception, not the rule in the nonprofit world, but it is something to keep in mind in the sense of having agreements in place that define what you're expected to do, what you're expected to create, and that work belongs to the nonprofit. So you can do that on the front end with an employment agreement. You can do it on the back end with an agreement transferring ownership of the work. And one of the things we'll talk about at the end is the concept of an intellectual property audit, which may be helpful for an organization to identify what do we have out there. Do we have our ownership established or not? If we don't, let's put the documents in place that transfer and establish the ownership. There's some other things to keep in mind when you're talking about founder IP. One, and it can be a sensitive topic, is did the founder really create what he or she is promoting and bringing to the nonprofit? It's an important question to ask because you don't want the nonprofit to risk liability for infringing uses of someone else's intellectual property. I've addressed this issue for-profit businesses and advised nonprofit businesses. You know, the quintessential example is saying, I love this photo I found on the internet. Wouldn't that look great on our website? Wouldn't that look great in our marketing materials? And people think that because it's on the internet, it's free to use for everybody. And that is absolutely not the case. It's certainly not the presumption you should be operating under. So, that's a pretty kind of apparent example, but there can be other examples of ways that a founder may have created something that he or she took from, maybe with the best of intent, maybe with no idea even or intent that he or she was appropriating something. But you have to be careful. You want to avoid and protect against claims of infringement from a third party. I want to touch on the concept of fair use because a lot of people have heard about fair use. It is, to me, one of the most interesting issues in intellectual property law, mainly because it's so unsettled and so difficult to predict on the front end. Fair use is a defense to a copyright or trademark infringement claim. It comes up mostly in the copyright context where you take something somebody did and you do something with it and produce your own work. Most fair use arises in the context of commentary or reporting or criticism of something or parody of something. So you're taking something somebody did and you're working it into something you're doing to comment or criticize or discuss it. One of the things that's important to know is just because you're a nonprofit doesn't mean you're entitled to use somebody else's work under the theory of fair use. That is not the case. Back to my photo off the internet example. Just because you do great work and you're a nonprofit doesn't mean you can use a photographer's beautiful image of something that's posted on the internet. But fair use is a very complicated legal analysis. It essentially depends on whether the second party's use is, the legal buzzword is transformative. Does it create some sort of new meaning to the first work? Does it create a new insight or new window or expression of the work? The other aspect is, does it negatively impact the market for the first work? Is it going to make it less likely people are going to pay money either to buy or license the first work? Businesses have spent millions and millions of dollars in legal fees litigating over whether a particular use is a fair use or not. The best advice I can give nonprofits is don't use something on the assumption that your use will be a fair use, because you can get into some very expensive and complicated litigation over that. It's better to get permission. It's better to confirm your ownership. And frankly, it's something that you should use the resources that this great organization might have available before you do something like that to at least give you a sense of whether you're treading in dangerous legal waters or not. The other concept that's a question that you ought to ask is very relevant is material in the public domain or not? The public domain has a very defined meaning in copyright law. It means something that either never had a copyright associated with it or that the copyright has expired. Usually it's the expired prong of that that's the most relevant. Copyright lasts a long time. We can thank the Walt Disney Company for that, wanting to protect all of their content created from the 40s and 50s and 60s. So you should not assume something is in the public domain just because you find it on the internet or just because you think it's old. Public domain means that anybody can use it if it is in fact in the public domain, but the flip side of that, it means you can't exclude other people from using it either. So it's an important concept, but it's not something that's sometimes easy to figure out. Back to the hypotheticals, when we look at this, did the Speakers Bureau, is that speech created by the nonprofit employee in the course of her employment and in her capacity as an employee? If that's the case, then the speech she gives is probably intellectual property of the nonprofit. The copyright is probably owned by the nonprofit. And in that case, it would probably makes sense that some or all of the money goes to the nonprofit. If it was created on our own time, if it was created using experiences from either before, as Robin alluded to, then it probably is not the property of the nonprofit. If it's a mixture, it can be a gray area. The moral of the story and the best practice advice is to address it on the front end and to have an agreement in place that is fair to the nonprofit, fair to the individual, complies with the tax laws, and documents who owns what. Some more questions. What about revisions or enhancements? A founder creates materials, a manual, a narrative, a work before founding the nonprofit, and he or she revises it and enhances it in the course of, after founding the organization and in the course of work. Again, if the founder is being paid, if he or she is doing it on behalf of the nonprofit, then the nonprofit clearly has the right to use that work, has a license, if you will, probably owns the copyright in the enhancements that were created while that founder was employed by and doing the work of the nonprofit. But there can still be a gray area about what was created beforehand. Copyright rights arise at the time a work is created. It applies to derivative works, that is, works, that are based upon or modify or are enhancements of the original work. And those derivative works might be owned by the nonprofit, may have some ownership interest in that, but you still have the issue of what was created before. So again, the best practice is to identify that, confirm ownership or use rights, and get that in an appropriate agreement so everybody knows what the rights are, and it minimizes the risk of disputes later. I mentioned at the beginning trade secret and name and image and likeness, and those are things, again, as I said earlier, a lot of people don't think about. And it is important to protect and take reasonable steps to maintain the confidentiality of information that you would be concerned if a competitor had access to. That's the best kind of layperson's description of a trade secret. Is if you think that information could be used against you by someone who's competing for the same customers, the same donors, the same volunteers as you are, then you ought to assume that you can protect that as a trade secret. And you ought to take steps to protect it, and you ought to make sure that your employees are treating it confidentially as well. Now, the founder may bring to the nonprofit his or her own lists or information. That's, again, a gray area and potential for dispute. Material generated on behalf of the nonprofit while a founder or other employees are working for the nonprofit should be the property of the trade secret of the nonprofit. But it may not be the case that materials brought from prior to the founding of the organization would be the organization's intellectual property. Again, an agreement in place would be the right way to address that. And use of the founder's name and likeness, obviously if the founder is the face of the nonprofit, then you don't really need an agreement in place because you have a pretty clear implied license that you can use that person's name or image to promote it. But what happens if the founder leaves or has a falling out? My recollection a while ago is the original Habitat for Humanity founder had a falling out, and there was even pretty acrimonious disputes between the founder and the organization. Now, Habitat probably wasn't out there trying to promote that original founder's name and likeness, but your nonprofit may be really closely associated with the particular founder. And if that person is no longer there, there can be an issue. Historical facts, historical references are probably okay, but using that person's name and image to promote the nonprofit after he or she is gone can be a problem. So again, agreements and documenting things like that on the front end is the best practice. We talked a little bit about licenses, or I've referred to licenses. A license is just a legal term for permission. It should be in writing. You can have implied oral licenses, but that's kind of not the best practice. An exclusive license means you have the exclusive right to use it. The non-exclusive license means you can use it, but other people can too. As I said, they're implied licenses. If you pay for things, even if you don't get a written assignment, you have an implied right to use it, but that's, again, not the best practice. And this is kind of beyond my IP area of expertise, but I've certainly seen situations where there are restrictions imposed on how a nonprofit might use work that was created based on grant funding from particular organizations. So that's something that you should just be aware of. That's more of a contractual issue than an intellectual property
Ron,
issue. But it's
I have a couple of questions that go back to kind of license, if this would be an okay time to ask. One of our viewers was asking, is there a time limit if you have been using the IP without an agreement? Is there kind of a time limit by which you should try to get those ownership or usage rights, or after a certain point is it implied?
Well, I think the answer is yes. That can be evidence if somebody allows you to use something for a relatively extended period of time. Let's say you use something for 3 years, then and that person knows about it, or that person or entity cooperates with you to allow you to use it, then you're going to be pretty safe for not, there's likely to be found an implied license that allowed you to use it during that period. What that doesn't necessarily do, however, is allow you to continue to use it. That founder or the third party may say, yeah, I've let you use it for the last 3 years, but I don't want you to use it anymore. I want to let somebody else use it, or I want to go into competition and I don't want you to use it. And in that case, the person may be able to say, I've let you use it up to this point, but going forward, here's my notice that says you can't use it anymore. So it's never too late to get a written license or acknowledgement or kind of going forward license. So it's obviously the earlier the better, but at whatever point you identify this issue, I mean, if you go back and you've had an issue that's, bubbled around for the last several years, but as a result of kind of being aware of some of these issues, you go back and talk to your executive director or your board, and you say, hey, we need to kind of focus in on this issue. It's kind of never too late to try to, move into the best practice realm, which is to get some sort of written agreement that gives you the right to use it and expresses the conditions under which you can use it.
And from a tax perspective, the more that you can have in writing with clarity between the board and the founder or whoever it may involve, the better, because it shows that there was thought and discussion and that they felt that it was reasonable and it was a reasonable decision. So having that evidence in writing would help if you're ever audited by the IRS to show that you made a good decision and that it was carefully thought through in making the decision if you have that evidence.
Thank you.
Sarisha, were there any other questions?
No other questions. I do want to point out it's 10:59, but otherwise, please continue.
All right. Well, I'll be brief, but let's wrap it up on this slide because I think this ties together a number of things that we've talked about. What are some best practice? What are some takeaways that you can take back and hopefully get some tangible action items on? The first thing is to think about what's called an intellectual property audit, and that's a formal term, and there are people out there who get paid a lot of money to do this, but you can do this pretty informally in your own organization as well. And really the point is to identify your intellectual property that you think is important to your organization. And there are several steps. The first step is just to canvass the organization and the people involved and identify what are the assets that either you know or you think could be intellectual property of your organization. So identify and catalog those. The second thing is, once you've identified them all, you look to document and get essentially a trail of the creation and ownership of that. And this may require some legal assistance to help assess the rights here, but you want to say, how were these created, who created them, and based on that, what do we determine is the kind of ownership title or trail for those assets. And the second aspect of the creation and ownership analysis is, if you either determine that you don't think the nonprofit owns these assets or appropriately has assignments or licenses, this is the stage where you can come in and do what Robin and I were just talking about, which is to say, okay, let's confirm the ownership. Let's get a license. Let's get a full assignment of the rights to this intellectual property. And that's where you can really button things up in the most appropriate way. And then the third aspect of an intellectual property audit is to say, okay, what are the processes we're going to put in place to make sure we protect this intellectual property going forward? Are we going to monitor other people, other organizations or people? When employees depart, are we going to remind them that this is what you can and can't do, with the information you had access to here? What trade secret rights might we have that we need to put particular confidentiality protections in place? So it's really those three parts: identify your assets, document ownership, and take steps to confirm ownership through agreements if you need to, and processes for future protection. The next best practice is for copyrights or trademarks. Secure federal or state registrations if you can, and you have the financial resources to do it. You don't have to have protectable rights, but it gives you more rights. And if you ever have to litigate, I hope you don't, but if you ever have to litigate, it gives you more rights. Written assignment agreements and written licenses. An assignment is transferring all ownership rights. A license is essentially a permission to use. But get those agreements in place where necessary, either to confirm your ownership in connection with the IP audit or to confirm your right to use if you've had a third party create something for you. Written agreements for both IP purposes and tax purposes, as Robin said, are far and away the best practice. And then consider agreements with your employees or volunteers regarding ownership of IP rights. It's important. It can be important on the creation end for things like copyright rights. It can be important on the permissions side for volunteers. You take a photo of volunteers doing work for your organization. You generally want to have a release or a permission that with the sign up that allows where people give you the right to use their photos with their image on your website or in your promotional materials. They're things that can protect you from claims down the road. So those are the handful of best practices. Again, I know we're up against our time, but I'm happy to answer any further questions or issues that anybody might have. And again, thank you for giving me the opportunity to discuss
We
with you.
did have a couple of questions that came in with pre-registration that I wanted to kind of bring up because I think it might do well to bring everything, bring it all together again. One person asked, does this apply to original artwork created by our founder that's incorporated into the logo of the nonprofit?
The short answer is yes. Someone who creates a logo or a piece of visual or digital art owns that creation. It's his or her, he or she owns the copyright, unless that person created it as an employee of the organization, or the person assigned the rights to that creation to the organization. So the organization may have an implied right to use it if there's no agreement and it was created beforehand. But if the founder leaves and the founder created it and brought it to the organization, there could be a legal dispute over whether the organization can continue to use the logo after the founder leaves and revokes permission. So get an assignment of the copyright right.
And one other one is, can the writer or creator who is the founder have an agreement to use that material outside of the nonprofit?
Again, I think the short answer is yes. That's legally possible. I don't think that would be a best practice for the nonprofit, either from an intellectual property perspective or maybe from a tax perspective, and that's the extent of my tax knowledge and advice you're going to get today. But you don't want, I mean, the copyright material is fundamental to how the nonprofit goes about doing its job. The logo or trademark is fundamental to the brand. You don't want that diluted by someone else having the right to go use it outside of your mission or your activities. So from a legal standpoint, you would want to secure exclusive rights to it. And then from a tax standpoint, I have nothing to say.
Yeah, you're absolutely right. I mean, if it's owned by the nonprofit, and an individual who's an insider uses it for personal gain, that would be improper, and it would need to be addressed by the board, and the board would need to approve it, and there'd have to be considerations for that. So just because something's created by the founder as an employee of the organization, or even as a volunteer of the organization, but doing it clearly for the organization, if they then go and take that and use it personally, there can be significant issues associated with that from a tax perspective.
Okay, that's all the questions that I have. Was there anything else that you guys wanted to say?
Nope. I think the last thing I'll just leave everybody with is like the takeaway slide, identify what you have and get written agreements in place to make clear who has the rights to what.
Great. Thank you so much, Ron and Robin, for speaking to us today, and to our viewers. Thank you so much for tuning in.